the session is divided into, let's say, sections. The first one is the major part of the session. It's basically the introduction into the overview of data protection GDPR, and then we have a short session or sub-session on the EOSC Future DPMS. That's probably interesting to know for some of you who are involved in the EOSC Future project and in the EOSC environment as well. Okay, let's start. First of all, a little definition. So when we talk about, so first of all, GDPR, everybody knows what it means. It's an abbreviation for the General Data Protection Regulation. It's a binding regulation, the European Data Protection Act, binding in all the countries that are part of the European Union. And this GDPR is about the protection of personal data. And personal data is everything that is in this blue box and much more. So basically everything that is or can be related to a natural person. So GDPR is not about protecting, for example, enterprise information. Like if, let's assume a company like Apple or Google or Microsoft, they have some very confidential, secret, like documents and information on their newest products, their technical specifications, patents, and things like this. So this information needs to be protected in the interest of the enterprise, but this is not something that is regulated under GDPR. GDPR only cares about everything that is related to natural persons. Yeah.
So research data, would that fall under GDPR or?
What? Sorry, which?
Research data.
Well, that depends on what the research data is about. If you do research on like health studies or something like this, where you have a relation to natural persons, then it is relevant. We will talk about this in a few minutes, but as long as it is possible to, based on these data, identify individual persons and relate these data to individual persons, as long as this is possible, these data are under regulation of GDPR. Only when the research data is completely anonymized, which means that there is no possibility in any way to relate anything back to a natural person, then it is not under the regulation of GDPR anymore. You know the difference between anonymization and pseudonymization? You know that? You call that in English, pseudonymization and anonymization. So to anonymize data means that you take, like, you adapt, you change the data in a way that there is no relation to any natural person anymore, and it's not possible to reconstruct that. Pseudonymization means that you just replace personal identifiers like name or whatever, by, for example, some cryptic ID or by some cryptic identifier or by a pseudonym or something like this. So that means these data are still under regulation of GDPR because maybe not everybody, but some people would be able to, basically to translate these data into personal data again. Yeah. So pseudonymized data are still personally identifiable. Okay.
A question.
Yeah.
Because we sometimes face a debate what personal data is with regards to corporate email addresses where you can identify the person. However, the person's email address, for example, is available publicly.
It is still personal data.
Okay.
So it doesn't matter whether it's available in public, how many people have access to these data. As long as it's an information that is related to a person, it's personal data. However, some personal data, like an email address which is published on a website, has a different need for protection compared to, for example, the health status of this person or information on the person's sexual orientation. So there are different levels of sensitivity and need for protection of different pieces of personal data. But an email address is always a personally identifiable piece of information. Right? So that's a very simple answer. GDPR is about processing of personal data. What means processing? So processing means any form of collection, recording, and use. So even just collecting data or being able to access data is already some form of processing. Even if you, like, I have a list of information, like a list of persons, a list of, let's say, a list of all of you who attend this session, as long as I get access to this information and I can read this list, have access to this list, this is already considered processing. So processing doesn't necessarily require transformation of these data. It can be just access, read, collect, store, everything is considered processing of personal data. And it does not matter whether or not the processing is happening in an electronic way or, for example, in a physical way. Like if I handed out to you a piece of paper and everybody would put their name on it, this would be an act of processing personal data. And this is also under the regulation of GDPR. So GDPR is not only about the regulation of electronic or IT-based processing of personal data. There are two important terms that you might want to remember after this session, because you will often read these terms whenever you read, for example, a privacy policy, a data protection policy, or a privacy notice on a website or something. The first is, the person whose data is processed is referred to as the data subject. So everybody in this room, we all are data subjects in many situations. Okay? When you register for this conference, you are a data subject because you provide information on yourself in the registration form to the conference organizer. And the conference organizer is the data controller. So a legal entity, for example, or a company organization that processes personal data of data subjects is referred to as data controller, because this organization is then under control to some extent of the data that this organization has collected or has been given access to for a certain purpose. Okay? So data subject, data controller. The basic case in processing personal data is that the data controller just processes data on one or several data subjects. That's the first picture. In many situations in practice, it's a little bit more complex than this. The most common situation you find in practice is the involvement of third-party data processors. That means that there is not only the data controller, but also subcontracted data processors that also process data on the data subject on behalf of the controller. Okay? That might be a third-party service provider, most of the time a service provider, for example, in a company where you have a lot of employees. Every employee is a data subject. Then the HR department of the company will process data of every employee, because they need to have like files on every employee, and they also have to, for example, process the monthly payment of the employee. Okay, in order to do so, like you are employed in an organization, you want to receive your monthly payment. So, in order to execute the payment, some data processing needs to take place. Your bank account details need to be processed, and sometimes it's another external company which is specialized on payment processing or HR management, whatever aspects, that actually does this on behalf of the controller. And the interesting thing is that GDPR says, from the point of view of the data subject, we all have a single point of contact when it's about the processing of our data, namely the controller. We do not need to care about the processors because the controller is responsible. He is in charge. This organization or company is in charge, and this organization has to make sure that the data processors provide sufficient guarantees to the controller that the processing of the personal data will maintain the data subject's rights. But we will look at this in a few moments in some more detail. These are the most, most important cases in practice. There is one more case which I did not put on this slide. It's called the joint controllership. So in some situations, you don't only have a controller, but you have two or more controllers jointly controlling the processing of data from one or several data subjects. This is not so common as the subcontracted data processing, but it's still also a valid and common model in data processing. The question whether or not you have joint controllers or subcontracted data processing, in some situations it's not very easy to judge what is the right model to choose. Sometimes it's very clear, sometimes it's not so clear. Well, for example, let's say 3 companies together organize a conference. Now, is that joint controllership in terms of like processing the data on the conference participants? Is it joint controllership? Do you have one controller and the others are subcontracted? Are the others not involved at all because only one controller takes care of everything? So there are different models which you might find in practice, and it's an individual decision on what model to choose. So we understand that GDPR is about personal data, it's about data processing, it's about controllers and data subjects and potentially third-party or subcontracted data processors. Did any one of you ever look at GDPR? I mean, really read GDPR or no? Nobody?
Parts of it.
Parts of it, okay. I probably didn't read entire GDPR, but I would like to encourage you to check this website, or there are other websites as well. I would like to you should be aware that this is a commercial website. This is not like the official European Union website or something like this, but I like this website because it's very easy to navigate. You can find other web sources as well. As you can see here, GDPR consists of 11 chapters and a total of 99 articles. The most important articles, from my point of view, are those. I mean, probably every article is important in some situation, but these are the articles that, in practice, I would say, cover 95% of the cases. And the other articles are about the other 5% of the cases, okay? So if you want to get familiar with GDPR and you want to read it, you might want to focus on these articles first. So Article 4 is about definitions. For example, the term personal data, data subject, data controller, data processing is all defined in Article 4. We will go through some of these articles. So the good news is you don't have to read it because I will give you some information on these articles today. The most important information, so you have an idea what these articles describe or require. So let's just start and have a look at Article 5, the principles of data protection. This slide, I see the slide number is missing, unfortunately. It's slide 9 actually. So this slide is basically a short summary of the text in Article 5. I would like to go to the next slide, which is basically the same but only the key terms. So this slide and this slide is the same content. This is more for you if you want to read it after this session. Principles of data processing. Lawfulness, specified purpose, data minimization, accuracy, storage limitation, and integrity and confidentiality. Let's start with specified purpose. Any data processing has to happen for a specified purpose and for a clear purpose. For example, I provide my email address to someone, then I have the right to understand what this person or this other, like the controller, for which purpose my email address will be processed. Will it be to take part in a survey? Will it be to subscribe for a newsletter? Will it be to register for an event? So the purpose must be clear in any situation in which data processing happens, both from the point of view of the data subject and from the point of view of the controller. So both parties need to be aware what is the purpose. And for this purpose I provide my data and for no other purpose. I cannot, for example, if someone provided their email address to register for a conference, I am not allowed to use this email address for a completely different purpose after the conference is over. Okay, that's important. The second is data minimization. Data minimization means that in a certain processing context, so when I process personal data, I will always try, as a controller, I will always try to process as like the minimum possible set of data. We will have a practical example on this one in a minute, okay? So let's keep this aside for a moment. Accuracy means that the data subject has the right that data related to him or her are processed in an accurate way. So for example, if I provide my address data, or these data are like stored in a wrong way, or there's like just false information stored in relation to me, I have the right to for rectification or to rectify, or to correct these data. So personal data need to be accurate in the context of processing and not reflect inaccurately the characteristics or whatever on the data subject. Okay? This is, for example, important when it's about things like bank or financial affairs. You don't want your bank to have wrong information on you, like wrong information on your income, wrong information on what credit you took or something like this. So things need to be accurate. Storage limitation. So there is minimization and there is storage limitation. Storage limitation means that when you store personal data, you only store them as long as it is needed for the purpose. That's interesting. Think about this conference. When you registered for this conference on the website, you provided some data. How long are these data stored?
Hopefully the duration of the conference.
Yeah, hopefully, like, as long as they are required to fulfill the purpose. The purpose is probably to organize the conference and to be able to properly plan the capacities and all this stuff, and issue your badges and issue your invoices and so on. But as soon as this happens, as soon as this is over, the data must not be stored any longer. That's important. That's storage limitation. Integrity and confidentiality is a little bit comparable to accuracy, especially integrity. Confidentiality means that whenever data are processed, this has to happen in a confidential way, in the sense that nobody gains access to personal data who is not required to have access in the context of the given purpose. So the data you provided when you registered for this conference should only be accessible to a very limited number of people, and only those people that really need these data in order to plan the event. And ideally you have a more differentiated access control, meaning that some people may access some of these data and other people may access all of these data, for example, depending on their role and depending on the specific needs. And then there is lawfulness. So this is an interesting principle. It says that data processing has to be lawful. That's a bit, what does lawful mean? I mean, when is it lawful? The good thing is Article 6 of GDPR clearly defines what lawful is, or what without lawfulness means. So we will talk about Article 6 in a few minutes, okay? So let's keep this in mind. And now let's have a look at a practical example, because I think the title of this session was GDPR and data protection based on real-life examples. So that I was told, so unfortunately I had to include some real-life examples. So this is the first one. To register for a conference, the following information need to be provided in the online registration form. Last name, first name, date of birth, nationality, email address, mobile phone, education degree, company, organization type, last conference you attended, and allergies and dietary requirements. My question to you, first of all, what is the purpose of data processing? How would you define that? Any idea?
Perhaps giving the best possible user experience.
Yeah, or attendee experience or something like this. Yeah. Probably a little bit vague, a little bit abstract. Should be a little bit more specific. Let me give you a suggestion.
To organize food.
Yeah, it's actually included here. To manage conference attendance, plan, organize the conference and related sessions, plan and provide catering, and communicate with conference participants in matters related to the conference. I'm not saying that this is exactly how you should define it, but this is a way how you could do it, and you could even add other aspects. But it's important that the purpose is clear and that it is comprehensible and that it's transparent for the attendee. So I provide my data, I need to understand what for. Okay, this is the purpose. Now, we have these data that we have in our registration form. Now my question is, think about the principle of data minimization, which I told you before. Is any of these pieces of information problematic from the point of view of data minimization? Which one, for example?
For example, date of birth, they don't need it for this purpose. The nationality as well. What next? The education degree. Concerning what is written there, okay, so maybe the company, but okay, they would like to issue the invoice. That's maybe fine. Your last conference you attended, it's absolutely, I did not answer anyway. Yeah. There are edges there, it's, well, okay. So maybe this has.
What about allergies and dietary requirements? Is that?
That's needed.
That's absolutely needed.
Yes.
Could be needed for the catering.
Yes.
Yeah. But should probably be optional. If I don't want to provide this information, I'm free to not to provide it, but it's not like forbidden to ask about it, right?
That's another question, what is actually obligatory question,
exactly.
Which can be skipped. That's just, okay, it's optional.
So let me give you,
I mean, the allergies and dietary requirements, of course, like, it's gonna answer only the people that have it, and they trust me, they want
it,
to know like the others to know, so I think it's not creating any problem.
So this is my suggestion. The red items, you should not even ask about them. You should not even ask about them, okay? Because there is no, from my point of view, no purpose or no relation in this purpose to process these data. The yellow things, from my point of view, you can ask about them, but you should not make these fields mandatory. In this sense, by the way, the registration form for this conference was questionable. You have a question?
Yeah, but for example, date of birth and nationality, those might be useful due to the contractors. So for example, when there are conferences that need to be organized due to dissemination reasons, then they are asking for diversity measures. And diversity in this sense, nationality and date of birth are usually important.
Valid point, but then you have to include it in the purpose as well. Then you have to evaluate the conference attendance for in the context of diversity requirements or something like this. And you have to add it to your purpose and explain in the purpose why these data are potentially needed. And still the question is if you have to make it mandatory. You could say, I asked for these data because it would be good to have these data in order to do this evaluation. But in the end, the question is this evaluation, let's say, is it more important than the individual rights and freedoms of the data subject? So this is an act of balance which is sometimes very hard. Okay, this is probably not, I mean, you would find other opinions on this, but this is clearly a way to look at it. And the interesting thing that you should maybe take away from this session is the minimization, data minimization principle according to Article 5 is not only like which fields are mandatory and which fields are optional. It's even about what do I even ask for. Even if it's a non-mandatory field, if the information you ask for is not in line with the purpose of its processing, you're not even allowed to ask for it. That's important to understand, okay? So please be aware whenever you design surveys or web forms and ask for personal data, ask yourself, do I really need this information and is this covered by the purpose, even if it's a non-mandatory field? Even then, okay? You have a question?
Yes, I'm wondering about the last conference you attended, why that one gets to stay as optional. How is that motivated?
Yeah, you could motivate it by saying, when I know that 50% of the participants attended a certain conference, I can probably match the program and maybe better match their expectations or some things like this. But I mean, your question is valid. You should probably add this to the purpose then as well and say we want to improve the attendance expectations or experience by also providing a useful program. And for this purpose, then this information could be interesting, okay, from my point of view. Okay, was that a clear example from your point of view? Now it's maybe clearer what data minimization means and how these principles work. Now, one of the principles in Article 5 was lawfulness. When is data processing lawful? Now, again, we have two slides. This is the, let's say, the slide which you want to read. And this is the slide which I'm going to use for the presentation because it's the same things, just limited on the keywords. So the first situation in which data processing is or may be lawful is when you get consent from the data subject. So I ask you, will you give me these data for this purpose? You say, yes, no problem. Then I have your consent and I can process the data. Then data processing is lawful. There are some restrictions about consent, which we will talk about in a few minutes, but for now, say consent is a valid condition for the lawfulness of processing. The second one is a contract with the data subject. Important, not a contract with the organization for which the data subject is working. So it doesn't matter if I have a contract with your employer. The requirement is it's about a contract with the data subject, so with the individual person. For example, you go to a car dealer, a car vendor, and buy a car. Then the car dealer will probably process some of your personal data, just to prepare the contract and just process the payment and all this stuff. Yeah. So in this specific situation, this data processing is not based on consent, because there is no other way. If you want to buy a car, you have to provide some of your personal data. If you don't, okay, you won't be able to buy a car probably, or at least it depends on the situation probably, but in most situations it will be difficult. So whenever there is what is another example? For example, if you get employed by a company, you get an employment contract, okay? So you enter a contract with your employer, and your employer will process some of your personal data in order to enter into this employment contract with you, okay? Contract. Then legal obligation. That is quite obvious. If there is a legal obligation for a certain company or organization to just process certain information or certain personal data, then it is also lawful. So if they have to do it due to a legal obligation, it's also lawful under GDPR. The next two, protection of vital interest and public interest, please be very careful with those ones. I assume that in most of the situations you get in touch with, they are not relevant. Vital interests are really vital in terms of life-saving interests. For example, you had a let's say a very bad car accident, and then the first responders and maybe the medical personnel in the hospital, of course, they have to process personal information of you. They have to determine your blood type. They have to investigate you. This is all processing of personal data, but you don't have to give consent. They just do it in order to save your life, and so far the data processing is lawful. So this is really about life and health of individuals, and so far vital interest. And public interest, that is dangerous, because some people might think, oh, what we do is in the public interest. EOSC is in the public interest. It's funded by the EC. So I just argue that we have a public interest, so we are allowed to do anything. That's not correct. Okay? Public interest is especially refers to, for example, police work. So, for example, police does some criminal investigation in a certain case. Then they, for example, they monitor a certain person, or they find out something about a certain person as part of these investigations. these investigations of a crime, for example, are in the public interest, and in so far they don't have to get the consent from the murderer. They just investigate the case and they say, okay, any data processing taking place here is in public interest. And then, now comes the joker. The joker is legitimate interest. So, when all of these other things don't work, the only option that remains is to say there is a legitimate interest. I don't have a consent, I don't have a contract, there is no legal obligation, there is no vital interest, there is no public interest, nothing, but the controller has a legitimate interest to process certain information on the data subject. Let me give you a very simple example, a very clear example that everyone will understand. Let's assume in this building, or let's say at the outside of the building, there is video recording, video surveillance. Is that processing of personal data? Yes, because you can see persons, you can identify these persons based on their pictures, you know that these persons have been at this place at this point in time. So this is obviously processing of personal data. When you enter the area in which video surveillance takes place, will you actively give your consent? No. Ideally, you are informed that video taping or video recording is taking place, but there is no consent, there is no public interest, there is no protection of vital interest. So the only thing to argue is to say the organization that has put the cameras there have a legitimate interest to monitor this area in order to prevent crime or to protect certain rights or whatever. Okay, this is mostly the reason why video taping takes place. Also, in the electronic world, in the digital world, a lot of things happen based on legitimate interest. For example, you access a certain web page and then let's say your activities, the user behavior is monitored on the website or by the provider of the website. Sometimes it's based on consent, so you have cookies which you accept, you have some other things that you accept, but most of the time, some of the things, for example, technical monitoring, often just happens based on legitimate interest without having the explicit consent from the website visitors.
So does it matter that if the camera is placed in a private home or something, or a public area?
In practice, yes. In theory, if you have your camera in your, say, private home and you have visitors, you are a data controller.
Yeah.
Yeah.
But is it then also, I mean, if you're afraid for burglars, is that still legitimate interest? I mean, it's your own home.
Yeah, but it's in your legitimate interest to protect your home from burglars.
Yeah.
Yeah. Right. You don't have, as a private person, you don't have to prepare a data protection policy or something like this for this case. Yeah. But from a legal point of view, it's as described. Yeah. Mm-hmm.
Yeah, it's my question is that what is the obligation of private people? Because okay, GDPR is so as a company we should take care of them, but as private persons, how we handle private data?
Well, a private person, like just a person, an individual private person in their private life, when I can be a data controller as well. Like if I invite my, let's say 20 friends to a birthday party, and then I set up an invitation list or something like this, from a formal point of view, from a legal point of view, this is data processing.
How about the photos on social media? Because it's so often, so common.
It's very difficult, and I think that in practice, so first of all, I'm not a legal expert, my background is IT, so when it comes to photos and videotaping and use of photography, I'm at a certain point in time I'm just out. And also I have to say that I think the jurisdiction in these specific cases is just not far enough to provide, let's say, specific and clear statements on this is allowed and this is not allowed. I know the problem with, for example, photography, for example, during a conference. Sometimes when you register for a conference, they just say, during the event, photos will be taken, and by registering, you accept that these photos will be published on social media. I'm 100% sure that if it came to a, let's say, decision in court, that would not be valid. Okay, that's the difference between theory and then practice and then again legal decisions.
I have just a comment. I'm a little bit afraid that as well in different European countries it will be a little bit different.
Probably.
That's highly probable.
Yeah, that's likely, probably likely. Okay, let's have another practical example. So I have like 5 processing activities, like situations in which personal data are processed. And let's think about what is most likely the legal basis for these processing activities. First, the participant registration for a conference. Consent?
Maybe contract.
Maybe contract, yeah. Because if you register for a conference, the question is, do you enter a contract with your conference organizer, and there will be some service actually delivered for you to do, namely the conference itself, to be considered as a service. So it's probably a contract. Subscription for a newsletter.
Consent.
Consent, right? Monitoring and tracking of user activities on the website. That's difficult. Legitimate interest? Might be. Could also be consent, yeah. Timekeeping of employees' working times.
And then consent by accepted cookies. I don't know.
You mean
that's
for the monitoring?
Yeah.
Yeah.
Okay.
Right.
Okay. Yeah.
Now, timekeeping of employees' working times.
It's a contract.
Yeah, it's the employment contract. In some countries, it might even be a legal obligation. In some countries, I know from Germany, they have a new legislation, I think, in this area. There is some legal obligation for companies to keep working times of their employees. Really. And video surveillance and recording in a company's headquarter building. Legitimate interest. So let me just, So it says for the monitoring tracking of user activities on the website, if it's, for example, for performance and security purposes, then you could say it's a legitimate interest of the controller to maintain the security and performance of the website and the website services. But if it's, for example, to enhance user experience, whatever that means, for example, to provide suitable ads or to provide suitable services to the user based on their behavior, this again has to be based on consent. And in the timekeeping context, it might be a contract, it might be a legal obligation, or even legitimate interest. That now very much depends on the situation. So what I'm telling you is that in some cases it's quite clear. In other cases, it's more maybe not 100% clear. Different options would be in general possible, and if you ask several people, several experts, you maybe get different answers, like in other legal areas as well, right? We talked about consent as one of the conditions under which data processing is lawful. The conditions for consent are very clearly set out by the GDPR. Namely, consent has to be freely given, traceable, presented, like the request to be presented in clear and plain language, and you have the right to withdraw it at any time. That's very important. If you base a certain data processing activity on consent, please be aware that the data subject may withdraw that consent at any time with effect for the future. So if you do something which will be very difficult to stop once you started doing it, please make sure that you thought about and reflected very well if consent is the right legal basis to base this on. And by the way, it has to be as easy to withdraw as to give consent. So it is not allowed that giving consent is just ticking a box and hitting a button, and then to withdraw you have to send let's say, a postal letter to a certain address and or fill out a certain PDF form which you have to then whatever, okay? So this is very clearly regulated by GDPR. And also, one thing about consent, I saw you have a question, just a second. One thing about consent is that freely given, most of the time freely given will not apply for employees of a company. Because employees are always in a, let's say, in a dependency with their employer. So let's say the employer says, hey, we want to process this and that personal data of you. Can you please consent to this? The employee, is he really free in his decision? I mean, is it really like, I'm completely free, I can withdraw it at any time? Or is it more like, if I don't give the consent, then maybe they find that strange and it will be, I will probably have some disadvantages. So consent is always very difficult in situations when there is a dependency between the data subject and the data controller, like in an employment relationship. So please be careful with consent in any situation where the consent is collected from the controller who is the employer of the data subject. Now your question?
Yes, so is consent needed when there are recordings in the conferences? So for example, for the speakers first of all and also for the rest of the audience?
So simple answer is usually yes. I mean, you might find some clever ways around it, but in most of the cases, yes. Recording, videotaping, also recording of, for example, Teams sessions or something like this. It's difficult without consent. It's difficult. But the other way around, it's difficult with consent as well, because let's say you have a Teams or like a conference call with 100 participants, and after 1 week, one of these participants says, I withdraw my consent. So what do you do then? So, difficult. Yeah.
What about consent to participate in data collection? What happens if you have a huge data collection where every informant has consented and you publish it, and then someone withdraws consent?
Yeah, then you have to be able to process this withdrawal and whatever, remove these data from this collection. If it's based on consent, yeah. If it's based on whatever legal obligation or legitimate interest, then it's easier. That's the reason why in many situations in practice, legitimate interest is what controllers prefer. On the other hand, legitimate interest is dangerous in the way that it's always, it is very much based on an individual assessment of the situation. Is my interest as a controller really, does it overweigh the individual rights and freedoms of the person? Because that's what you say. My interest is, let's say, more important than your interest of, let's say, not being filmed. Difficult. Yeah?
But if you have the data collection and you make it anonymous, then
you
solve the problem.
If we anonymize it, that's what we talked about before. If you anonymize the data, they are not personally identifiable anymore, then you can do anything you want. So that's why anonymization is a very powerful means of just scoping yourself out of the regulation of GDPR.
But what happens if you have a huge data collection and it turns out that, yes, it's anonymized, but by using this GPS coordinate with this time data and these aspects, you can in fact identify a person.
Then it's not, by definition of GDPR, then it's not anonymized. Then it's not fully anonymized. Anonymized really means that there is no way to relate any data to the identification of a certain person.
So with those kind of data, how do you know if it's possible or not?
That's your own assessment of looking at the data and saying, no, it's impossible based on these data to reflect back or refer back to individual persons. There is no, but I can tell you anonymization does not only mean I just remove the name. If the other information are still capable of identifying a person, then it's not anonymized. That's the definition in Article 4 of GDPR.
Can I ask you, for example, genetic data, can they be anonymized finally if you have a genomic sequence?
I'm not very firm with genetic data and in how far they are personally identifiable, so I have to pass on this one, unfortunately.
Okay.
Sorry. Yeah.
Regarding the recordings again, so the consent needs to be recorded, let's say, in the registration form.
Mm-hmm. For example, it has to be traceable. Like you have to be able to prove that the consent was given by this person on November 2nd, 11 o'clock or something like this. You don't need a signature or something like this, but you have to have some proof, some valid proof that the consent has actually been given.
And for speakers to upload their presentations or whatever, photos, blah, blah.
Well, the presentation is not so much personal. I mean, there is probably my name on the title slide, which you can remove, and but then of course you have the copyright issue maybe, but that's not a GDPR issue, of course. So from GDPR point of view, presentations are not really critical.
Unless it's personal stuff you're presenting.
Yeah, of course. Yeah. Talking about this presentation, for example. Okay. The data subject, so everybody in this room has certain rights. These rights are described in Articles 12 to 22 of GDPR. I think the most important one is, for example, or is from my point of view, the right of access in relation to transparent information. Transparent information means that whenever not only when I provide the data, whenever my data are processed, whether or not I myself provided them or they are gained from another source, whenever my data are processed, I have the right to have transparent information on what purpose these data are processed for and how are they processed. This is the first one. And the second one is right of access. Means you can go to any controller processing personal data on you and execute your right of access, and then this controller has to provide you with a full copy of any information that this controller processes on you in a common digital or electronic format. So it's not sufficient, like a few years ago it was sufficient if the controller just told you, we are processing some of your data like your name, your email address, blah, 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 and that's it. Today they have to provide you with the data themselves, not only with the model of these data, but with the actual data. So you have the right to receive and to access the actual data processed on you. Means that if you ask for this right, for example, against Facebook or Google, you might get like hundreds of pages of PDFs of different types of data. Yeah. Okay, did you know that? So you can execute this right against any controller, and most of the times people do that when they feel bad about certain things that maybe happen or don't happen in the context of certain data processing.
What I would get if I asked the controller who is doing the surveillance camera.
The what?
The controller who is doing the surveillance cameras.
The surveillance cameras.
Yeah, but
that depends on when you ask, because most of the time video. So today, I think that any GDPR compliant organization will not keep video recordings for longer than, let's say, three days, maybe 7 days.
Okay, I will ask in this period. So what I would get?
The problem is that they have 4 weeks to reply.
Okay, so you will reply that doesn't exist.
Yeah, they will probably reply that there is no recording that shows you in this.
Because they have nothing, but they could give you.
Yeah, right. Correct. Okay, so there are other rights which I will not go into the details now. And then there is, did you ever hear about data protection by design and by default? You know that? That's Article 25 of GDPR. It says that any controller has to implement appropriate technical and organizational measures and integrate necessary safeguards into the processing in order to meet GDPR. That sounds a bit abstract, but I will explain to you what that means. Let's assume you are, let's say, processing certain personal information by the use of a certain tool or IT system. then the rights and the principles that we discussed, especially for example, the right of access, or the principle of data minimization, or the principle of storage limitation, should be implemented into this process. So whenever today a company, for example, develops a software in which personal data are processed, the software should provide a function that makes it easy for you to delete certain personal information after a certain amount of time when they are no longer required for the given purpose. So that is data protection by design, means that you don't have to, let's say, go into the database in the back end and then by very complicated measures have to find out which data records need to be deleted, but you have this function integrated in the function set or the functional set of this software product. Maybe let's have a look at the example. I think it makes it clearer. For example, you are a developer of HR management software. So HR management software is a software that a company may use to manage their employee data and employee files and everything related to their employees. Then by design means that this software should support state-of-the-art encryption. It should support state-of-the-art access control with multi-factor authentication. So technical and organizational measures. But it should also support pseudonymization or anonymization for example, reports generated. It should provide an option to limit or restrict data access and export. And it should provide an option to set a retention or deletion policy for a given data set. For example, in a HR context, if you have like recruiting data, so data from job applicants, then these data have to be deleted once the actual process has been concluded and the position has been assigned. Okay, then you have to delete all the, let's say, applications from other people who didn't get the job. And an HR management software or recruiting management software should support this, should actively support this. And it shouldn't be very complicated for you to do this. You see what I mean? Ideally, it's an automatic process, which is embedded in the functionality of the software. And this is data protection by design. And by default means that the most data protection friendly option is the default. That applies to, for example, software. So let's say you have a software and then you have two options. You can activate encryption or you can deactivate encryption. You can activate multi-factor authentication or single-factor authentication. Then the more data protection friendly option should be the default setting. So the default is always it's activated. Or in a form, in a web form, where you, let's say, register for a conference and then there is an option, I would also like to register for the newsletter. But it's optional, okay? Then this checkbox must not be pre-selected because the more data protection friendly option is that you do not agree with this. But if you want to agree, you have to actively agree. So the default setting, the default functionality in any processing activity is always what is more data protection friendly. That's what data protection by default means. And this goes together because if the software or the activity is not designed in the way that you have these kinds of options, then you won't have any defaults. So design and default is basically two sides of the same thing to some extent. Is that clear? Because that's a little more complicated now, but I guess it's important to understand as well. Okay, let's have a look. We have talked about this model. You remember from the beginning, you have a data subject, a data controller, and maybe a data processor. It is important that in these kinds of situations, controllers shall only use processors providing sufficient guarantees to implement appropriate technical and organizational measures to meet GDPR. And usually, this is governed by a contract, and this contract is called a data processing agreement. Have you ever heard of this? So in many situations in practice, you have a controller and a processor, and between them you have a data processing agreement in which the controller governs what the data processor is allowed to do or not allowed to do. Most of the time, the data processing agreement clearly states, okay, you will do this and that, this and that. For this purpose, we will provide you with access to the following data, and you are allowed to do this and that with the data, and you are not allowed to do anything else with the data. And in order to protect the data, you have to implement these and that technical and organizational measures. A DPA can be anything between 2 or 3 pages up to 40 or 50 pages, depending on how strict and how detailed and fine-grained you want to govern the activities of the processor. I'm actually more a friend of 2 or 3 pages rather than 40 pages, because my feeling is that if you have a 2 or 3 pages DPA, it's realistic that everything that is on these 3 pages will actually be done, while everything on the 40 pages will probably just be ignored because it's too much. But, okay. As I said, I don't have a legal background, because legal experts usually tend to the 40 pages version.
Because they are paid for the page.
They're what? They're paid
for the page.
They're probably paid for the page, and they also want to, how do you say that in a professional way, save their ass.
Yeah.
They don't think so much about practicality and effectiveness, they more think about saving their ass, and that's just like a different approach, right? I do like legal people, I really do. But every controller must maintain records of processing activities. So everything, transparency is a very important concept in GDPR. And when you are a controller, like you are a company, an organization, and you're processing personal data here and there, it's not just enough. It is not enough to just be aware that we are processing personal data here and there. You have to actually define what here and there is. So you have to say, we are processing these personal data in this specific context, and we are doing this kind of data processing in that context, and then we also organize some events, and as part of this, we also process personal data. And you have to basically create a list, an inventory, whatever you call it, a database of all your processing activities, in which you clearly define what happens, what is the purpose of processing, which personal data are processed, who are the data subjects, and many other things. So transparency. So ideally, when you go to any organization who processes personal data, and I can tell you every organization in the world processes personal data at some place, you can ask them for their processing directory, and ideally they will be able to show you, this is our list, these are our whatever 12 processing activities that we have. It's important when you set up a processing activity that you do not consider the things like that your granularity is not too low or too high actually. So for example, in the HR context, when you look at the HR department of a company, they process personal data in many different situations. They process data in the context of education, professional education, recruiting, HR management, salary and payment processing and all this stuff. You can of course put all these things as different, as like separate processing activities, or you just call the whole processing activity just HR management. So question is, what is the best way, what is the best approach? Sometimes it's probably better to be a little bit more, let's say, abstract, and so insofar that you have not so many processing activities that you have to manage.
Is it possible to include in GDPR some future gatherings that for sure, for now, we are not gathering that, not processing that, but in the future, maybe. So are we allowed to note that in GDPR?
Like for example, the organizational events. We might provide you with this, and that's the reason why we need to process your data.
Okay, but then you have to, I mean, and what is the question? So if
currently we are not collecting something, but in the future maybe. So are we allowed to
in advance, put it to the policy in advance.
Sure, why not?
Okay.
Yeah. But you have to be aware that in the situation when it actually happens, you have to then clarify what is the legal basis, do we need consent, do we have a legitimate interest, whatever. So in this situation you have to be clear about what are we doing. But of course you can, yeah.
But also, I think if you want to save data, it also needs to be. So if you're now saving data for maybe in the future, if you're going to use it. No?
Because of the future events, we might need to process
In the future.
Yeah.
Yeah.
Okay, so that is records of processing activity, and then there is a term that you might hear from time to time. It's the so-called DPIA, the Data Protection Impact Assessment. GDPR says in certain situations you have to actually assess and understand the impact of some processing operations, and especially prevent data processing that in situations that would result in an unacceptable risks, to the data subjects. So, for example, whenever you process, for example, very sensitive personal data or very large amounts of personal data, then you would have to perform a so-called DPIA. And what is that? A DPIA is basically more or less a risk analysis, but you do not consider the risks for you as the controller. Like it doesn't really matter what are the risks for the company. You have to consider the risks from the point of view of the data subject. Like you have to change the perspective and think about, would it be a high risk to the individual rights and freedoms of the data subject if I did this kind of processing with his or her personal data? This is basically what a DPIA is. So in general, you are allowed to do a DPIA whenever you process personal data. You can, even before you start a conference registration process, you could do a DPIA. But actually, to be honest, if for a conference registration, I mean, you ask for name and email address and dietary requirements maybe, and that's it. This is not really something for which you would have to go through a DPIA. But in other cases, you might want to go or have to go through a DPIA, especially when it comes to these personal data, which are defined in Article 9 of GDPR, namely special categories, sometimes also referred to as sensitive or highly critical personal data. These are any data revealing racial or ethnic origin, political opinion, religious or philosophical beliefs, and trade union membership. Also, genetic data, biometric data, health data, and data concerning a person's sex life or sexual orientation. The slide here says that the processing of these categories of personal data is bound to special prerequisites. If you look into Article 9 of GDPR, you will find a very interesting sentence. You will find the sentence, the processing of special categories of personal data is prohibited, full stop. They just said it's prohibited. But then the article continues and says, except if, and then there are all the prerequisites. Okay? So, at first you are maybe a bit surprised, well, it's prohibited. I had an interesting discussion the other day about religious and philosophical beliefs, because I don't know, I can tell you my experience from Germany. In Germany, your religion, for example, if you are a member of the Catholic Church, this is something that your employer needs to know, because it has impact on your on the tax you pay, on your salary. I don't know if that's the same case in other countries, maybe special situation.
They more or less.
So it's about the I would call it church membership fees, but in German it's a tax. In Germany it's a tax.
Okay.
So it's and it's in so far the employer has to know about your church membership, so to say. And I had a discussion on this because I said that in a way that means that every employer processes special categories of personal data on their employees because of this specific information. And then the other person in the room said to me, yeah, on the one hand you're right, on the other hand, it says religious or philosophical beliefs. And just being a member of the Catholic Church does not automatically mean that I really believe everything. You see what I mean? So that I found is an interesting discussion. I don't know what the truth is and how maybe a judge would decide on this, but interesting perspective, definitely. Yeah.
Yes, but then it's the same for political opinion, that I'm a member of a political party doesn't mean I have the same opinion.
Exactly, exactly. And that's interesting because in these very specific questions there is no right or wrong. There is, I mean, some people will have this opinion and others will have that opinion.
Yeah, but this goes back to the basics of the law and who is deciding if it's correct with the law or not. So this is the judge, as was mentioned, usually at least in main part of the European countries.
Yeah.
So until this is answered by the judges, that it's unclear.
It's
and
unclear.
you can, in good belief, try to do it the best way.
In good belief, make a decision for yourself or for the situation. And do you think that, based on what I just told you, you now have a better understanding of GDPR? Did you have a feeling that you understood the key principles and everything we talked about? I think you should be aware.
What happens if it's breached?
Yeah, violations against GDPR. This is also set out in GDPR. So the controller can get a penalty for violating GDPR with their processing activities, and the penalty may be up to 4% of their annual financial turnaround. Turnover. So so the fines, the penalties can be quite high in monetary terms for the controllers violating GDPR.
And if the controller is a private person?
Difficult.
Yeah.
And it would be your personal income probably. But I don't know any case in practice.
It depends on the state country law. Because, for example, in Poland we have this bill.
Yeah.
It says that if someone gets insurance, like money, because of the breach of the rules by the civil servant, government, and so on, then the state can go back to the employee, the clerk, and said for about half of your annual salary can be taken back, but by the court, of course.
Oh, wow.
And or maybe.
But that is then only relevant for in the specific context of employmentship and not like in a
only as
completely
it
private.
comes to public administration.
Yeah, okay, I see.
Only public administration, but
okay.
it is possible because state is at first is have to pay.
Yeah,
so it
I see what you mean.
regress to
Yeah, I see.
the
I didn't know that. Interesting.
Yeah.
I don't know if that's.
It's probably that bill because it's not used often. It's very difficult as it comes to the like proof.
Executing.
And no, maybe not executing, but there are some obstacles that can prevent someone from this fee. But it's possible and it's legal.
Okay, interesting. Okay, good to know.
I have one question concerning the example which was given earlier. When we had the human resources, we had the applicants, for example, then I select someone and I deleted the rest. This is fine, but I have backups.
Yeah, that's a problem.
Should I delete the backups as well?
You should. The answer I have to give you is yes. And in practice, yeah.
I expected this answer.
Yeah, it is. And backups is always a problem when it comes to storage limitation. Always, in any organization I know. It's always the problem, what do we do with our backups? They just argue, okay, but the backups are really, they are not even accessible for the persons usually working with these data, they are only accessible for some IT administrators, and then in the event of the backups being needed, then they would be restored. But okay, you can maybe find ways around it, but yeah, backup is always difficult. Just some additional information. So I'm standing here today because I'm also a consultant in the EOSC Future project for data protection related issues. Fleur is the data protection coordinator for the EOSC Future project. The problem with the project is that the project by itself is not a legal entity, so it's very hard to look at the project as a data controller. We would have to look at all the partners in the project as being data controllers themselves. I mean, they are just organized in a common project, but every processing activity taking place is under the controllership of one or several parties within the project, and not of the project itself, because the project itself doesn't really exist as a legal entity. And so far, what we did in EOSC is we did set up a data protection management system, but not in the way that we consider the EOSC Future project as a controller, but more as a supporting, let's say, tool. By the way, the term DPMS is also a term from GDPR, so controllers are required to set up a so-called data protection management system. And this usually consists of some policies, processes, responsibilities, and tools to effectively manage the lawful processing. For example, what I told you before, the processing directive, where you just have a list of all your processing activities. This is part of your DPMS. It's just a bunch of documentation and the related processes and procedures on how this documentation is maintained, on what you do based on this documentation, and so on. And what we do in the EOSC DPMS is, the first goal is that we want to create a solid level of awareness and promote exchange on data protection among the EOSC participants. This session today is basically part of this goal, but there are other efforts we take as well to increase the level or increase the awareness for GDPR and data protection among EOSC partners, especially, of course, in the context of their process-related activities. To this end, we also want to provide clear and pragmatic guidance and support. And the last one is to create transparency of the data processing activities. We assume that every partner in EOSC is a data controller in some situations themselves. To this end, they have to comply with GDPR. To this end, they have to maintain records of their processing activities. What we want to achieve is that we at least know which of these processing activities are happening in the context or in the scope of the EOSC Future project. So we do not want to know every processing activity that takes place at any organization involved in EOSC Future, but we want to know at least for those processing activities that happen in the context of the project and the project's working activities and work packages. Okay? So what we do have is a data protection policy for the EOSC Future project, which you can find in the wiki, right, in the Confluence wiki. The policy more or less addresses some of the things that we talked about today and puts them in the context of the project, more or less. And then what we also have is guidance and support, and for example, we do have templates. For example, if you need a data processing agreement or a joint controller agreement in the context of the EOSC Future project, because you say, okay, as part of the project, we organize an event, and 3 partners out of the whole consortium will organize this event, so we want to set up a joint controller agreement. How do we do it? You can just take this template from the EOSC DPMS in the wiki and just prepare it. It's not binding, it's not mandatory, but what we want to do and what we promise the EC is that we provide to the EOSC Future project, let's say, practical support in achieving GDPR compliance in the context of EOSC-related activities. And that's what this DPMS is basically for. However, in the end, every partner, every beneficiary, every organization, every third party, in the end, as a controller, is responsible for what they do. they have to comply with GDPR. Because EOSC Future as a whole cannot be made accountable. Only the specific organizations can be held accountable in the end. Okay? And that's more or less the idea behind the DPMS. Just to give you an impression, so this is, for example, how the this is one entry or processing activity that is currently recorded in the processing directory of the EOSC DPMS. So we say that there is an activity which is managing internal communication newsletters mailing lists within EOSC Future, and this activity is carried out and controlled by the partner Arctic. So this is the responsible partner, and then we just describe how it is done. So the description is more or less what is the typical contents of a processing directory. And ideally, we want to achieve this for, let's say, the majority or the most important activities in which personal data are processed within the EOSC Future project. So transparency, okay? Transparency, guidance, awareness, and some practical help. So it's not like we are not setting up a huge, complicated whatever system. It's really like these 4 or 5 things that we focus on, and it's really about not making your life harder, but making your life a little bit easier, especially when it comes to support, guidance, and awareness. Yeah.
And in case of trans-European projects and contracting, which national GDPR rules apply?
So the GDPR as a regulation, not as a policy, is directly applicable in every member country of the European Union. So there are local or country-specific data protection laws and legislations, like in Germany, the EOSC, or there are probably other country-specific legislations. But in the end, everything I just told you, all the articles that we went through quickly today, they are directly valid and applicable in any country. And to be honest, I'm not aware of other country-specific legislations than the ones that are.
No, in the Netherlands as well, sir.
Yeah, there are, but I don't know them.
Oh, okay, no.
I'm aware that they exist, but I don't know what they.
I think the GDPR provides a base level, which has direct effect to all citizens.
Yeah.
And like Germany, you can be more ambitious. So you can be more protective to your citizens if you want to, as a country, but this provides a base level.
But you can also do the other one, the opposite. You can justify certain exceptions. Sorry?
Yeah. Ask about the religion, for example.
Yeah. Okay. That's Okay. That was the end of the session. I hope it was helpful. I told you it was the most exciting topic in the conference, and I think I didn't promise too much. If you have any other questions or want to get in touch, don't hesitate to contact me or Fleur. And I hope you had a wonderful week here in Prague, and have a safe trip back home, as I think the conference will more or less finish in a few hours, so maybe 1 or 2 more sessions. Thank you for joining. It was a pleasure, and thank you for being so interactive. Good to meet you, and see you soon. Bye-bye.
Thank you.
Thank you.